Hello, my name is Sarah Brett and I'm the Regional Head of HR and Legal South at Make UK. This is the second in three pre-recorded webinars on the topic of making redundancies in the context of Covid-19. We're going to start today by looking at the issue of can you collectively consult during the pandemic? The first point to make is that the basic position is a matter of law as to whether statutory collective consultation is triggered. So it's not a matter of choice. Collective consultation is triggered when you first propose 20 or more redundancies within a 90-day period. So when your proposals for redundancy become firm enough to meet this test, you must begin collective consultation. So that question becomes academic. The fact that you may have practical challenges does not actually impact on whether the legal duty has been triggered or not. So I'm sure most of you are sighing because you're starting to think about some of the practical challenges that COVID-19 will cause you in terms of carrying out this collective consultation. So inevitably the whole process may take longer and it will require very careful planning. So you may have employees working at home or employees who are furloughed or otherwise not working. They may be looking after children, be self-isolating or shielding, or perhaps living with someone who is shielding or vulnerable. Or you may be in the situation that most of your employees are at work, but perhaps you have social distancing measures in place which would impact on how you carry out a normal consultation. So what about the impact of furlough? Our view is that employees participating in collective consultation would not count as work. So it should be possible to carry out collective consultation during furlough. You will not be jeopardising your government grant monies. With regard to reps, employee and union reps, you'll be glad to hear that the government guidance was updated on 30th of April to make it clear that it's fine for union or union reps to undertake duties and activities for the purpose of individual or collective representation of employees or other workers, so long as they don't provide services to or generate revenue for or on behalf of the employer or an associated organisation. So what that means is that it doesn't count as work to jeopardise your government grant payment if you have your reps carrying out consultation duties whilst on furlough. So there might possibly be an argument that full-time TU officials are providing services to the employer as that's their usual job. However, we think that you can argue that in performing this aspect of their duties, full-time union officials are providing services to the employees that they represent and not to the employer. What's the worst that can happen if Make is wrong on that? It would mean that the employer can't claim under the job retention scheme. There wouldn't actually be a breach of the law on collective consultation. We do think, however, you need to be careful about work carried out by, for example, managers who are actually running the collective consultation period and HR people. If those folk happen to be off on furlough, then their grants under the job retention scheme would be put in jeopardy because it does count as work when you're hosting meetings, making decisions during the consultation period. So they would be working and they would fall outside the requirements for payments under the job retention scheme. It is worth carefully considering how you time this collective consultation and how that's going to fit in with your eligibility for grants under the job retention scheme. Many of those of you that I've been speaking to have told me that you may struggle to pay employees during consultation or notice periods. So it's quite important that you are able to claim under the job retention scheme for the duration of pay of, for example, notice period. So again, that may be a factor in you deciding to start collective consultation sooner rather than later whilst employees are actually on furlough. So moving on. In today's circumstances, what practical steps should you take? First, in relation to the managers who will be responsible for running the collective consultation period. So this slide actually assumes that your business is not operating as usual. So we're assuming that you've got employees temporarily working at home, maybe furloughed or otherwise not at work. So the first thing to do is to decide who will be involved in running the collective consultation. Which HR staff? Have you got senior managers to run meetings and to be available to answer queries and make decisions? Do you need assistance from IT? You'll then need to consider if they're able to undertake the tasks required. If they're currently furloughed, then you'll need to end their furlough and bring them back to work. If they're not on furlough, then how feasible is it for them to participate? For example, do they have caring commitments which would prevent them being able to do this? And then another important consideration, that lovely topic you all love, GDPR. What information and data will they need access to in order to carry out their responsibilities? And are you satisfied that it can be shared in a sufficiently secure way? Maybe you need to do a data protection impact assessment. Again, speak to your advisor if you need and model one of those, because clearly there are more risks when you've got special category data flying around on in home circumstances, on individuals' own devices maybe. So it's not as bad as you might imagine, because the ICO has indicated it will take account of current circumstances when considering any breaches of the normally stringent GDPR rules. But you do need to take care of the basics. So stress to all those involved that personal data must be kept securely, and limit who can see it, and only process it in keeping with the purpose that you've communicated. You might need to do an updated privacy notice to employees if you're going to be using their data in this redundancy exercise. So get all that taken care of. Then consider about reps. The employer is responsible for deciding how many reps should be elected. So how does furlough and home working impact on numbers of reps for your organisation? The most important thing is having a really good channel for communication. Have you got special measures for those who are particularly isolated? Clearly, any redundancy scenario is an emotional time for those who are affected, and we know about how Covid-19 has had considerable bearing on individuals' mental health. So you might need some additional well-being measures in place, and what happens if some of your reps fall ill or cannot participate because of changing requirements of Covid-19. So these are some of the additional considerations you need to take into account. So you will be used to thinking in any standard redundancy exercise, can any given rep represent a whole group, or do you need to look at different classes of employees? How does it really work for your business in terms of the practicalities, who they should be representing? And are you going to have certain minimum requirements for the role? Do they need to have time to attend virtual meetings, to prepare properly for those meetings, to liaise with the constituents? it may be more important than ever that those individuals who put themselves forward for election of reps have good internet access. It's clearly important they have a minimum level of IT skills, although you could of course provide training. So think carefully about how you're going to gather nominations and how you'll run a ballot if there are more nominations than positions. A secret ballot is probably easiest. Can you do this by Google Forms, voting buttons, etc., or are you just going to use standard email? The important thing is that everybody can participate and that a degree of confidentiality is kept. It may take slightly longer, it may even be quicker, but get those reps in place. So, what about communication with affected employees and reps? At the start of the redundancy period, you will need to make an initial announcement to affected employees, explaining that a period of redundancy consultation is about to begin. You'd also need to cover off who their reps will be, or the process for election for reps. If you've got employees on furlough, it's a good idea to first communicate via the method you agreed when you placed them on furlough. So maybe you said you'd keep in contact by email, text, etc., so that they do actually know that there is such a meeting going on. If you want to, you then could agree a different method of communication between yourself and the affected employees going forward. So what about the practicalities? Do you need to provide IT equipment, an iPad, a company mobile phone? Do you need to agree an expenses policy to reimburse reps for phone bills, etc.? What steps do you need to make sure that to make sure that information and personal data is secure? Some of our members have actually set up a hub for communications between themselves and the reps. The advantage of that is you limit the amount of personal data flying around, and it makes it slightly easier for the reps to comply with GDPR. As always, Make UK has come up with a really helpful plan here of a collective consultation process. I'm sure many of you are familiar with the plans that we've previously had on our website for a standard redundancy process. This time round, Make UK has gone one step further by building in the additional requirements through furlough, etc., to allow for virtual meetings and to give you an idea of how you should actually spread those out. So do think carefully about the initial announcement to all affected employees. Could you just do it by webinar rather than a virtual or real meeting? How you get everybody engaged. If you are going to meet in person, perhaps you're doing this at the end of a furlough period, do think about the all important social distancing measures. Perhaps to comply with government guidance on social distancing, you'll actually need more than one meeting so that you can have fewer people in the room. It is fairly important that you think of a way that you can give the information simultaneously to those affected. Do think about those who are outside of the workforce and maybe those on maternity leave, sick leave, etc. And think carefully about how you're going to maintain that contact. So set the date and times for each meeting at the start of the consultation process. Setting people's expectations is important in minimising the pressure on all those affected. And your planning is critical here. Make sure you have all the information you need for each meeting. You want to be in the driving seat here so that you can preempt and answer as many questions as possible. If you need help drawing up some frequently asked questions, they may be slightly different from your standard ones because of COVID-19 and furlough. We can assist you with that, and think about how you're going to run the meetings themselves. It may be a slightly different method for tabling questions than a standard redundancy process. Is it better to actually get those questions in advance? It will give you the heads up on how to answer them. Also think about the rules and etiquette for video meetings. Those of you who've recently done Skype meetings, perhaps without video conferencing, will know that it's sometimes difficult knowing when individuals should speak. So having clear rules of etiquette for video meetings will really help. The next consideration is, can you just say, oh, well, we couldn't do consultation because of COVID-19. We've heard that there's this legal exception called special circumstances. Surely that would apply, equivalent to act of God, a pandemic, such that we'll be excused from having to do consultation. Well, you are right. There is a defence called special circumstances, which applies when it's not reasonably practicable to comply with collective consultation. But our experience in any court cases to date has been that that is a very high hurdle to jump over as a business. So although the current emergency may count as special, and clearly you're going to have some challenges in complying, you must carry out as much consultation as you possibly can. We think that whilst it might technically be possible, it is fairly rare to be able to end the collective consultation prematurely. You can only do that if all consultation is exhausted. But that difficult judgment call as to whether you can cut to the chase and draw it to an early end, earlier than the mandatory 30 days or 45 days. As we've said, it's rare that you can do that. So do speak to your local Make UK advisor before you make that judgment call. So how to run a selection process in COVID-19 times. How are you going to get fair selection criteria? Clearly, you don't want to just select those who are on furlough. That would be straight away unfair. Your biggest risk here is that you get an unlimited damages discrimination claim. It might be worth looking at your lists of those who are furloughed. But many members have told me that they have actually noted that when they analyse the list, that there are more individuals with protected characteristics on those furlough lists. So let's go for something objective as the focus for deciding who you keep on for the future. Let's, for example, focus on the skills you need after lockdown and make sure you have an objective selection exercise. If you're going to have to test for the necessary skill set, then you will need to carry out additional measures so that it is a fair selection process, for example, for those working remotely. Many of you will be familiar with having to modify your test, for example, if somebody's got a disability, by allowing more time. It's the same as your children, maybe those of you who've got children doing university degree exams from home. They need to neutralise the impact of poor Wi-Fi coverage, etc. The same kind of considerations if you're requesting that individuals are tested whilst working from home. So if you've got people with caring responsibilities, perhaps looking after children at home, do allow them more time if you're carrying out some kind of selection exercise. We've already covered the point that there is a high risk of discrimination if you go for those who are on furlough, because those who are self-isolating, shielding, or have childcare issues will have protected characteristics. As always, if you're ever making any pregnant employee redundant, definitely take legal advice. There's a super duper additional duty on employers to prefer individuals who are put at risk of redundancy whilst on maternity leave, to give them priority over and above even better qualified candidates if there is suitable alternative employment. So do tread very carefully. In my experience, most employers tend to use a settlement agreement for employees who are pregnant or on maternity leave, if they are making them redundant, because it is such a high risk area. Also, do have an equalities risk assessment before you embark on a redundancy exercise. So you think about, for example, how you're going to communicate, how you're going to score those who are off long-term sick. You should still include those on permanent health insurance schemes, etc. And of course, do consider before you start the redundancy exercise what your general position is going to be about bumping. So bumping, whereas an employee comes to you and says, well, instead of making me redundant, why don't you let me take the, for example, lower role of ex-employee and bump them out. So you, as a good employer, have to say what your strategy is on bumping, and most employers will say that they are amenable to considering any requests on bumping, but that they will actually deal with any requests on the merit of their own situation. So, for example, if you think an employee will not stay with you in the long term if you give them the lower paid job and bump out the other person, then that would be a legitimate reason for saying on the facts of any request that you're actually refusing that request for bumping. When it comes to pooling and you are struggling to think how you pool people, then look at job descriptions, etc. But also consider whether there is a degree of interchangeability between the individuals involved. So do they, in normal circumstances, cover each other's holiday, cover each other's sickness? If they do that in practice, then that's a pretty good guide that they should all be in the same pool, and that you should be selecting from the whole pool rather than just going for certain individuals. So some selection criteria are less risky from a discrimination perspective than others. Last in, first out, gone are the days when that was a standard redundancy selection criteria. It is fairly high risk. Something subjective like attitude, approach to work, again, high risk. Much better to go for the neutral examples here in the green boxes, like qualifications, training, customer relationships, etc. You can include things like attendance record, length of service, but be very careful how you present those. Do neutralise attendance records so that it's not disability discriminatory. Flexibility, be careful how you present that one. I'm not keen on that one because it's more likely to impact against those with caring responsibilities. Sometimes employers include flexibility, meaning ability to do several types of role, but again, be very careful in how you judge that if you are going to include it. this is an example of a selection matrix for a skilled employee. That one looks a sound one to me. You can weight certain criteria if they're more important to the business. Here I would suggest that you align this to the requirements of the business going forward. What distribution of employees with certain skills do you need to keep your business viable and successful for the future? When you carry out your one-to-one consultation, you would normally have an at-risk meeting giving the at-risk letter. You don't have to give the right to be accompanied there. You'd soon after have a first consultation meeting when you'd explain the business reasons and look at suitable alternatives. Then have a second consultation meeting and then a final consultation meeting, and then you would tell the employee the decision in writing, and you would in some instances give the right of appeal. Most of you, in my experience, give the right to be accompanied at the final meeting and also give right of appeal. Now, if you're doing a collective redundancy consultation, you can start the individual redundancy consultation say midway through the minimum 30-day consultation period or minimum 45-day consultation period, but you need to be very careful that you don't give notice to terminate until you've got through that minimum 30 or 45-day period. So it may be much tougher having these individual consultation meetings, specifically because of COVID-19. I suspect you'll be relying much more on video calls. Your managers may need more training in how to handle some of the sensitivities around that, so that people still feel properly engaged in the consultation and feel supported. I've already flagged up well-being. That's a big issue in how you will run this process, and it could make a significant difference if you can remind your employees about what services you offer in terms of perhaps counselling support from any kind of medical services that you have, like the Westfield Health support that Make UK offer our members. So you may need to be slightly more creative in terms of who their accompanying person can be if you're going to offer that as a right. I think it's a good idea to offer that, and perhaps rather than saying that it has to be a work colleague, you might unusually say a member of the household can be present instead on a virtual meeting or on a telephone conference call, and you clearly need to anticipate what you'll do if it gets very emotional or a family member starts getting aggressive. I think the obvious thing to do is call a halt to the meeting, have a breather, and be very clear on what the role of that accompanying person is, and if necessary you'll have to ask for that aggressive accompanying person to leave the meeting. What will you do if employees do not engage in the process? That's a tricky one, isn't it? I mean, clearly you will need to expedite the consultation process, but maybe get HR to speak personally to the employee to find out if there are any issues causing particular concern. And then once you have been able to give notice that an individual is redundant, if, for example, they're still going to be in furlough during their notice period, then it is important that you keep in touch during the notice period, and that you can demonstrate that throughout the consultation for that individual you have considered any suitable alternative employment. So that's all we're going to cover in today's excerpt. Next time, in the third and final chunk, we'll be looking at calculating redundancy pay, the impact of furlough on when you serve notice, and most importantly, what the risks are of unfair dismissal, specifically because of the furlough scheme. Thank you very much for joining today's brief recorded webinar.